All right. So I'm working with Enrique Seira, who's here, and Chris Woodruff on courts. A little bit about the problem. We know that courts function very badly in many developing countries. Among other things, we have lack of predictability of outcomes, and we have a lot of delay. There's, however, little rigorous evidence on the effectiveness of courts, and we're trying to contribute to that. We find a few facts that are interesting. Low settlement rates, even though they're very long trials, so you'd expect people to have high incentives to settle. There's a low level of recovery compared to what people ask for in their lawsuits. There's misinformation. A lot of people who are suing don't know what the legal severance pay is, or they don't know what they asked for in their lawsuit. And finally, there's a lot of overconfidence. When we ask people on both sides of the same lawsuit what their expectations are of the probability of winning, it adds up to almost 1.5. So, it can't really be very realistic. And then another big motivation is that recently Mexico passed a very important constitutional reform in labor law, which will force a conciliation stage to happen before the lawsuit can be filed. And we're trying to be involved right now in the design of the federal labor law, which will implement this constitutional reform. So here I'm going to let you see some results from previous pilots, which were financed by JPAL. The first thing is this notion of giving parties statistical information about how people similar to them did before. And this is where we've used sort of machine learning techniques. So what do we find from these previous pilots? If you give people statistical information and or you force them to talk to a conciliator, then we find that we almost are able to double same-day conciliation on the same day as the hearing. But this effect is only due to those cases where the employee is present. And the effect is persistent, but we don't find that the lawyer later on gives the employee any information. So if we only give the statistical information to the lawyer, there's no evidence whatsoever that this is transmitted to the worker later on. Okay. So now let's talk about the current project that EDI is funding and about the research hypothesis. So the first is, does statistical information increase settlement? We already know from these previous pilots I just showed you, the answer is yes. Can we, by forcing people to sit down, not forcing them to settle, but forcing them to sit down with a conciliator, can we increase settlement rates? Also the previous pilots say yes. But these previous experiments have given us indirect evidence that lawyers matter. So information only seems to help when it's given directly to the person who's sued. So the question really is, do workers' lawyers play a role in the misinformation and the overconfidence? And that's kind of where the current experiment is focused mostly. So let's talk about three hypotheses. Number one, many private lawyers inflate workers' expectations to convince them to sue. So we're going to be able to get evidence on what workers claim before they talk to the lawyer and then look at their lawsuit. So we're going to get some direct evidence on this. Second hypothesis, information on likely case outcomes may not be enough for people who come at the very beginning when they just have the labor dispute and they know nothing. They may need help with a strategy, like nudge them. So we're going to have some nudge treatments. Third hypothesis, early information provided to workers may help them to select better quality lawyers. So this may mean that we have higher quality lawsuits and they may obtain more at the end of the procedure. And we think this is very relevant because in many developing countries and in many markets, we have examples of markets for some kind of public service that's important, could be health, education, justice, where one side of the market is not a repeat player and suffers from severe informational problems. So the question is, how can we intervene using large databases, big data, using machine learning techniques, transmitting information in a way that would improve the initial information, okay? What's our design? So we're doing a randomized control trial in the field. It's a cross design, but you'll see that there's like an extra treatment. The big deal about this particular intervention is we're intervening when the worker has just had the conflict and they have not yet even consulted a lawyer. So we solve the problem of how do you get to talk to the plaintiff themselves? Because at this point, they're not yet plaintiffs. They're just showing up to ask for help. We have 1 control and 4 treatment groups. All of them answer the same baseline survey. The control group receives basic information about their legal rights. The 1A, which is the public lawyer nudge, we give them this basic information, and then we give them free transport to the public lawyer's office. Then in the next treatment over, we give them the calculator, which is the same thing we tested in a previous pilot. So we give them detailed information, and we give them the statistical information generated by machine learning. Then we also do, the next one should say 2B, we do giving them the statistical information and giving them the nudge to go to the public lawyer's office. And finally, this is the one that's not in this 2x2 treatment. We do the letter of appointment, which is detailed information, the calculator, and giving them a letter of appointment to call the firm for a conciliation meeting. The reason this is included is this is exactly what the constitutional reform says that the law has to become. So we're actually testing what the effects of that would be. Okay, so going on, we get data from surveys. We ask baseline questions. We ask questions at 2 weeks and at 2 months. We find out about outcomes of the conflict. Did they settle? Did they sue? Did they do neither? We look at their expectations at the baseline and updated at 2 weeks and 2 months. We look at the lawyer, how they found the lawyer. So we're trying to get here at lawyer quality because of that third hypothesis I talked to you about. And then we also look at welfare measures. So we ask them about their job status and how much hardship they've had economically due to having been fired, durable goods spending, and so on. We also get data from the court. We get, number one, we calibrate our calculator based on a large database of concluded lawsuits of similar characteristics to these workers that we're dealing with in the experiment. And then we have all the information about new filings, either of cases, lawsuits, or settlements that are directly registered at the court. Okay, so here are some preliminary results. In the statistical information calculator plus the letter of appointment, we have a 15 percentage point increase in solving the conflict out of court, which turns out to be about 30% over baseline of those people who show up and just get the basic information on the survey. But also the treatment of only giving them the calculator has some significant effects. It actually makes it less likely for them to talk to a public lawyer, but also much less likely for them to sue with what we call an informal lawyer. These informal lawyers in Latin America are called coyotes, which is a despective term, and it's on purpose because they are actually not licensed lawyers. They catch you outside the court, and then they may pass you on to a licensed lawyer, but they're low quality both professionally and ethically. Okay, so that's an interesting question. Why is this happening? Are we somehow substituting the information that they sometimes need to get from a first contact with a lawyer, and then we're making them get better quality lawyers? This is a question. We also find, this is another bit of results to show, that expectations are updated and they predict settlement. So this is a bit complicated. We ask people at the baseline about the probability that they evaluate of them getting something at the end of a lawsuit, and we also ask them about how much they think they're going to get. So if you look at the first 2 columns and then the 5th and 6th, these are just dummies of, did they lower their probability of winning, the expected probability of winning, based on our intervention? And did they lower the amount that they thought they were going to win based on an intervention? And so it turns out that those, first of all, the first stage shows that it does affect this. It does cause them to be more likely to lower. And then if we look at the second stage, this decreases, the fact that they've decreased their expectations due to our treatment is causing them to conciliate more, okay? So there's some more evidence about the channel going through expectations, which is something that has been difficult to establish before, okay? Okay, so now I'll talk about challenges and our next steps. Right now, we've treated slightly over 2,000 subjects. We may be able to continue running this in the next calendar year, but right now there's a big change in government and there's the reform coming. So we're only 100% sure of getting about 500 more subjects in the fieldwork. The biggest challenges and where we need feedback. We have only an 80% response rate for the surveys so far. So we've been working with different kinds of bounds. They still give us significance, but not so much on the pure statistical information treatment. Also, we had a really big problem, our free transport, like nudge to go to the public lawyer, which is, we want to kind of find a way to instrument experimentally for the decision to go to a public lawyer, was destroyed by an earthquake. So the public lawyer's office, collapsed, and they came to the court for 8 months. And now they just moved back out of the court. So now we're doing this treatment again, but we have results that look very promising on this nudge treatment as an instrument, but we don't have enough sample size. So if we can continue running the experiment in the new year, we may take that opportunity just because of that issue. Matching the names of the workers with the court data, administrative data, is also an issue for us. But the biggest thing we want feedback about is how to measure lawyer quality and lawsuit quality. Because the interesting thing is here we have an uninformed principal who is generically uninformed in many developing countries in a justice or in a public services situation. And we want to improve the quality of the decisions that they make. So we'd like to see if we can actually measure what lawsuit quality is. So we have some objective measures, we have some subjective measures, but these subjective measures depend on getting lawyers to evaluate case files. And they also involve probably doing more sophisticated machine learning stuff, converting things into text, doing semantic analysis. So we would like to sort of explore that more and get your feedback on it. And also how to measure welfare in the short term. We're asking some questions that are standard, but it's very difficult to establish the welfare results. Okay, so.
Just super exciting. Just wondering if you have very strong priors that public lawyers are better than private lawyers.
Public lawyers are better than informal private lawyers, and they're probably quite a bit worse than the good private lawyers. The problem with private lawyers is that it's very difficult for a worker that's uninformed, that's only going to be fired maybe once in their lifetime, doesn't have any sort of way of communicating with other workers who got fired, unless it's like your next door neighbor, and that's going to be a non-representative sample, to find out about who's good and who's bad. So one thing we're interested in, first we have to nail this thing of measuring the quality in a way that people consider to be both the professional, the legal community has to kind of think this is right, but also academicians have to think this is right. So it's a difficult thing. And if we were to be able to do that, then maybe with the new institutions, we could actually run some kind of experimental thing where some kind of credit bureau / TripAdvisor type of thing for lawyers who litigate in these labor courts on the worker side. But I mean, that would be like a dream come true. But basically, there's a distribution in how we've measured so far. The public lawyers are on the leftish side of the distribution, but they're by far not the worst law firm. There are quite a few big law firms that are awful. Right? And they're the people who buy the cases from these coyotes and so on.
Do you have access to the track record of lawyers? What other cases they have?
Yeah, so we have lawyer names. So the way we get this data is through the transparency law. And of course, because the court wants to cooperate and work with us, as you saw. But the way it works is, since they don't have anonymized data, and because we've convinced them that the location of where people live and the name of the lawyer and the name of the law firm is actually important for the research we do, so we have access to all that. And we have data, we potentially can have data from the last 6 or 7 years in which the court has scanned the case files. So that does give us a track record. Now it's an internal track record. If the guy litigates in family court as well and does,
no, fine, but, but for a moment, kind of bracketing off the problem that they may have different selection criteria for what clients they take. In principle, you could develop a score of lawyer
Yes.
effectiveness that you could
Yes.
use for
Yes, we
measuring
could.
quality.
Yes, but this is why it's important. I mean, at least the public-private issue is important to do this sort of, to get results from this nudge treatment where you get a free transport or not to the public lawyer's office, because otherwise the selection problem of who goes to public lawyer kills you, right? So this is the problem. And with the private lawyers, I don't know how it would work if we wanted to try and introduce some kind of mechanism to create reputation, but it would be sticky.
And is there anything like a generalized Mexican Bar Association example or something?
No. Unfortunately, there isn't, and there is, in many areas of law, there's very low quality. So I'll give you an example. The Supreme Court in Mexico, 8 months ago, ruled that if you've signed a power of attorney for your lawyer in labor court, which you might sign on the sidewalk with these coyotes, they can drop your lawsuit without you physically being present. Can you imagine? Right? They drop your lawsuit, they sell it basically for a couple of thousand pesos. So people are very vulnerable.